Assalamualaikum everyone. My name is Adlan Nabil bin Abdul Farid.
My name is Muhammad Ashraf.
My name is Munif Afifi bin Sarabil Fikri.
My name is Lukman Al-Hakim bin Muhafizan.
My name is Ryan Said bin Rashid.
And my group will be presenting about consideration can be a promise not to sue. So basically, consideration can be a promise not to sue means, let's just say if one party has a possible civil claim against the other party, a promise not to enforce that claim can be good consideration for a promise given in return. So for example, let's say Anne crashes into Ben's car, and Ben agrees he will not sue Anne only if Anne pays for the damages caused. So basically, Ben's promise not to sue is consideration for Anne's promise to pay. So basically, an act of forbearance to enforce legal claims can be good consideration.
So, the name of this case is Alliance Bank Limited and Crimson. So, what is the main concept behind this case? So the concept is an act of forbearance to enforce a legal claim can be a good consideration. So before we move on to the facts of the case and the decision of the court, we first have to understand what is forbearance. It is in the concept that I have mentioned just now. So forbearance, according to Merriam-Webster Dictionary, is a refraining from the obligation of something like a debt, a right or obligation that is due. Alright, so what are the facts of the case? So this is just the summarized version of it. So Broom owed the bank money in an unsecured loan. Because of that, the bank asked to provide some security for that loan, in which the defendant agreed to, provided that the bank would not sue him. However, after some time, the bank still enforced the debt, and because of that, the defendant, Broom, argued that the bank had no consideration for his promise to provide security. So, the question from this case is, could promising not to sue Broom constitute a good consideration for his promise to provide security? So, what did the court decide? What is the answer to that question? The answer is yes. The forbearance to sue, or for the promising not to sue Broom, did constitute a good consideration. So, if we see, the bank gave Broom ample time to provide the secured loan in return for the debt to be settled. But after some time, Broom still did not do anything about it, and because of that, the bank had to enforce the debt. So because of that, there was consideration for the promise, and since Broom did not do his part in securing the loan, so the court decided in favor of the plaintiffs, which is Alliance Bank Limited.
I will continue to my second case law, which is Com v Com. So what is the fact of the case? So there is a couple who is undergoing a divorce. The husband made a promise to the wife that he is going to pay her £100 every month without tax. So the wife makes independent decision upon hearing the promise. She did not apply to the divorce court for order of maintenance due to the divorce. So because what? Because he believed in the promise of the husband, but upon your divorce, the husband didn't pay her a single dime. So which makes the wife bring this file or bring this suit to the court. The wife demand the husband to pay her £100, and she said that the husband had made a breach of contract because there is a clear and valid contract between her and the husband. But the husband said that there is no consideration, which means there is no contract upon her and the husband itself. What is the decision from the court upon this case? So surprisingly, the court has been favored towards the defendant, which is the husband. Why? Because the court says that there is no valid contract that has been happened between the husband and the wife. The husband promised, although the husband has made promise to the wife, but there is no consideration back from the wife toward the husband that can create a legally binding contract between her and the husband at all. Furthermore, even if there is a contract, even if there is a contract that exists, it still can be void due to the amount of the money that has to be given to the wife is not being determined by the couple at all, but is under the power of the jurisdiction of the court himself to determine. Okay. So what is the relation between consideration is a promise not to sue and this case law is you can see how a consideration, a promise for not to claim can be considered as a consideration if the opposing claim is equivalent to the act of a party to not enforce the claim of itself.
Thank you for the group members for briefly explaining about the rules of consideration, which is regarding our topic, which is consideration can be a promise not to sue. Therefore, I'm going to give the commentary on the relevance of the rules of consideration regarding our topic. And for that, I'm going to need the help with my friend, which is Rhino.
But before we get into that, we would first like to give you guys an example of this rule before we get into the commentary.
And so for the example, one day A caused an accident to B, which caused B to suffer a neck injury and also some damage to his car. And so A promises to B that he will pay for the medical bills and also pay for the damages that caused to his car. And so B agrees. But several weeks later, B says that he's going to sue A. And then, although A has already paid the medical bills and the damages, and so A says that B cannot sue him because there is a valid consideration and also A has already paid the medical bills and the damages. So when there's a valid consideration, there's also a valid contract between both of them. And therefore, the commentary and relevance of both consideration
Is that a promise not to sue can be taken as a valid consideration when forming a contract. As mentioned by my friend Lukman and other examples given by Munif and Achab, it shows that consideration does not necessarily have to be physical things, as we have learned that it can also be services done, but consideration can also be in the form of a promise not to sue. So when there is, as we all know, when there is a valid consideration exchange between parties and there's offer and acceptance, then you have a valid contract.
In conclusion, one party's promise not to enforce an existing claim can only be amount to consideration if the promise given a return was induced by the promise not to enforce the claim.
That's it for my case. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
So that's all from me. Assalamualaikum warahmatullahi wabarakatuh.
So that's all. Thank you.